to address the House.
Thank you, Mr. Skhole, and our apology for starting a bit late. Program Director, members of the media and other honored guests, Public Protectors, senior management, investigation staff, ladies and gentlemen, good afternoon. Welcome to our last media briefing for the year 2014. As you know, we are releasing 4 investigation reports today. 3 of these are on service failure and 1 is on conduct failure. Just as a reminder, service failure is when somebody was trying to get a service in from a government establishment and the service was denied, delayed, or was in a wrong quality. And conduct failure is when people behave wrongfully, such as corruption and governance failure. As I reflected on the last 11 and a half months, I thought of the words of English writer Charles Dickens when he said the following, I quote, "It was the best of times, it was the worst of times. It was the age of wisdom, it was the age of foolishness, it was the epoch of belief, it was the epoch of incredulity. It was the season of light, it was the season of darkness, it was the spring of hope, it was the winter of despair." In the last year, we have experienced the best moments and the worst moments. Yet, all in all, it was a great year. As the Public Protector team, we got unprecedented positive feedback nationally and internationally. We also got unprecedented criticism, mostly nationally. Both helped us grow, and we're grateful for both the positive feedback and the negative feedback. The turbulence rooted us, while the positive feedback energized us. And as I've indicated, we're grateful to all of you, regardless of which side of the coin you may have occupied. The important lessons we have drawn from some of the events that occurred this year have certainly helped us as a team and as an organization to grow. As a result, we continued to be a resource to both the people of South Africa and the government, a resource the midwives of this democracy envisioned us to be. We continued to facilitate dialogue between the state and its people, serving as a buffer between the two. A few months ago, we informed Parliament that we had dealt with a total of 39,000 cases during the year ending in March 2014, finalizing 24,000 of those cases. While still on the numbers, we've noticed that we have been undercounting. For example, if you look at a report that we released this last Monday, titled Law and Justice, you will notice that it is not one complaint. In that report alone, you have about 6 complaints unrelated to each other and involving different institutions. In our case counting, that is counted as one case. An overwhelming majority of the cases we dealt with last year involved service failure, which predominantly affects ordinary people of South Africa, the ones we refer to as the Gogodlamenis. A portion of the workload dealt with conduct failure. Even though the conduct failure cases were smaller than the service failure, I must indicate that we've seen a tremendous increase on this front, particularly with regard to cases relating to procurement irregularities. That is a source of concern. One of the lowlights of this year is that we saw a number of senior managers leaving this office for greener pastures. You may be aware that our former Chief Executive Officer, Mr. Mthethwa, has since been appointed Community Housing Ombudsman. We congratulate him in this regard. Our former CFO has gone back to the property industry from where we had found him. The head of the Western Cape province, whom we refer to as the Public Protector Representative, Advocate Ruthven van Janse van Rensburg, has joined the Western Cape provincial government as a forensic investigator, while the provincial representative heading the Gauteng province just resigned a week ago, also got a better offer at DDG level. We wish them the best. We have moved with speed to fill some of these vacancies. For example, we've already conducted interviews for the Chief Executive Officer and the Chief Financial Officer. We will be filling those vacancies soon. Resources remain a big problem for this office, and this continues to hamper our ability to make the difference we were meant to make. You will note that some of the cases we're releasing today have taken far too long to finalize. The same applies to the cases we released a week ago. I would like you to note, though, that sometimes it looks like it took too long. Our investigations have a two-staged process, some of them. Each investigator investigates and makes a decision on their own, supported by their supervisor. They may decide that there was no merit in the allegations and decide to close a case. And the supervisor, together with the provincial representative or the branch head, may agree. And if they agree, they sign a closing report that I never get to see as the public protector. And that's how most of our investigations are concluded. However, if a complainant is not satisfied, we have an internal review system. So these complaints will come back and be reviewed by a review panel that would then advise me on what to do with the case. Often we decide to reopen these cases. You will see then some of these investigations that we've done and for which I'm releasing reports today would look like they've been with us since 2010, whereas some of them were closed as closing reports at some stage. And when the matter came to me on review, I decided that the investigation did not meet the standard, or rather, there was new information that the complainant had brought to us, which provided a basis for reopening the case. And then we opened the case and re-investigated. Just to remind you that we indicated to Parliament that we were going to approach development partners on the issue of possible support for resources, and we've done so, asking them to assist us primarily around the area of training, so that whatever money we have does not go into training and goes into our core programs. We had a good discussion with many development partners, and all of them showed some interest. A key area of interest was the possibility of benchmarking between our office and the Ombudsman offices and other investigation offices in their country. On the question of benchmarking, we've also just come back from the UK, where, courtesy of the United Nations, we were able to travel and we're able to benchmark with the Ombudsman Office in the UK and with the parliamentary committee to which the Ombudsman Office reports. We have exciting information that came from that benchmarking exercise, which will see us review our strategy and refocus some of the things that we're doing. We are also hoping that we'll help the parliamentary committee we report to link up with the parliamentary committee in the UK, where the Ombudsman reports to, for benchmarking purposes. One of the events of the last year was a judgment that had implications for how government deals with reports I issue after investigations. I would like to just confirm that our respect for the judiciary remains intact, and we understand that until a higher court makes a different finding, how government reacts to the reports we are going to issue today will be informed by that judgment. However, I must indicate that my understanding of the judgment is that it focused on what should be compulsory action from government. But when it comes to what is government's responsibility to its people, the rules remain as enshrined in the Constitution. And you will note that in the reports that we are releasing today, we've brought in the Batubili principles, including the right to a remedy. Going back to the main reason for today's briefing, I have already indicated that we are releasing 4 investigative reports. These reports have the following titles: Cost of Broken Promises, 5 years and counting, Fish Farming Paralysis, and a Matter of Interpretation. I would like you to note, though, that last week we also released some reports. Those reports went under the following title: Unsettled Business, which dealt with a former employee of an organ of state who wasn't given some of the benefits that were given to people at her level. And we made a finding that one of those benefits should be given to her. Saved by notice and out of the blue are 2 reports on appointment of staff without proper qualifications. And we made findings in this regard and advice on what they could do in the future. And the last report that we dealt with has implications for the broadcast media. It is called Law and Justice. The emphasis there is that we have a constitutional responsibility to transform everything we do to ensure that the key principle that governs what we do is justice. Just because the law allows you to do something, you don't have to do it if it's neither just nor fair. And that's the essence in law and justice. The key issue also there is the rights of performing artists, specifically rights in relation to copyright. I would like to advise that as we move forward as the Public Protector South Africa and as part of our strategy, we will be avoiding emphasis on disciplinary action when we are investigating service failure. Our strategic shift is to get organs of state to look at what happened, what should have happened, what caused things to go the way they did, and how do we avoid it in the future. The reason we'll be shifting away from disciplinary action is that when there's an emphasis on punishment, people tend to hide mistakes. And when it comes to service failure, we would like to take government's hand and move with government around really picking up these service failure incidences and systemically uprooting them. I can't say the same though for conduct failure. Of course, if we investigate corruption, fraud, in other forms of malfeasance, we may still place some emphasis on punitive sanctions, depending, of course, on the circumstances. So in these reports here, whenever we're dealing with service failure, you will not see remedial action that says we should find out who dropped the ball and make sure that they pay for it. We would like them to find out how did the ball get dropped and how can they avoid doing it in the future. I will start with the report titled 6 Years and Still Counting. It is a report that is issued in terms of Section 182, 1B of the Constitution and Section 8.1 of the Public Protector Act. It communicates my findings and appropriate remedial action I'm taking in terms of Section 182, 1C of the Constitution, pursuant to an investigation into alleged maladministration by the Gauteng Department of Infrastructure relating to the department's administration of the Seke Bosrand project. This project involved the upgrading of the water supply to the nature reserve in the area at the cost of 8,667,745. I will just go swiftly into the findings there. The key finding is that there was maladministration in the handling of the project, from its procurement to monitoring that timelines were kept and quality was adhered to payment of service providers. As the title indicates, it's 6 years and still counting. Yet the project was supposed to start in May 2008. It was supposed to start in November 2008 and end in May 2009. It was a 6 months project that took 6 years and it's still incomplete. We have then requested the department to look at what went wrong with a view to ensuring that this doesn't happen again. Somewhere in the report, I indicate that government has decided to focus on infrastructure as part of the National Development Plan. If a relatively small-scale project takes 6 years when it was supposed to take 6 months, you are worried what's going to happen to large-scale projects. So again, we're not really saying anyone should be punished as such unless the department sees fit. Ours is find out what happened, why were the requirements of a proper procurement system not followed, in that there should have been proper demand management. There should have been a proper procurement process that ensures that the most suitably qualified company was given the project. There should have been proper supervision of the project, including project management, to ensure that timelines were met. And this didn't happen. Project that was supposed to start 17 November 2008 and end 20 May 2009 remains incomplete. The next report. Oh, before I go into the next report, you will notice that I didn't read the statement in full. I'm just giving you the highlights, but it will be available as a summary for you to see the exact findings. The other key finding is that there is somebody who's still owed. A subcontractor is still owed in an amount over 5 million. Again, I've drawn government's attention to the responsibilities government has towards small business enterprises and the importance of cash flow to small enterprises, and reminded the Gauteng government about a decision I made recently in unsettled settlement, where again we highlighted the importance of making sure that small enterprises are not squeezed out of cash flow. And in this regard, government has been asked to act speedily to resolve the issue of the subcontractor. This company is not the main contractor, is a subcontractor, but the contractor is saying they're not able to pay because government hasn't paid the contractor. And the remedial action I have called upon the department to implement is to go directly and assist the subcontractor to the extent that it can be proven that the subcontractor is owed. The next report that I would like to go to goes under the title of Fish Farming Paralysis. The report deals with a project again that was somehow procured by the municipality of Bujanala in the Northwest Province around 2009. This project never took off. The complainant is a certain Mr. Meli Hendrik Mdluli, who is also an emerging contractor. His main complaint was that he was strung along by the department, having brought the project to the department as an unsolicited bid of some sort, and the department agreed that it would partner with him on fish farming in the Bujanala district municipality. Initially, he wanted to do this at a municipality called Jericho, and the municipality persuaded him to move it to another municipality within the broader district municipality that is poorer, called Mulatedi. My finding generally here is that the municipality managed this project very badly. It didn't crystallized the project in its IDP. In its IDP, it just had a project for poverty alleviation. It didn't clearly include aqua farming or fish farming, as it told the complainant. It also didn't really apply its mind to the mechanism that was going to be used to regulate its relationship with this company called APC, or Aquaculture Project Consultants. Because the municipality had not applied its mind properly to the legal mechanism it was going to use, it sent him backwards and forwards on different mechanisms. At some stage, it said it was going to be a public-private partnership, PPP, and then asked him to go and draw up an instrument. So this is just an ordinary person. He obviously would get a lawyer to draw up an instrument to execute this relationship. When he came back, the municipality had now received advice to say, no, it can't be a PPP, and then it turned it into an unsolicited bid. And he was asked to go and draw an instrument for that purpose. Having drawn that, the municipality got advice to say it shouldn't have entered into this. It should have put this on tender. Then it told him it's going on tender. This was about 8 to 9 months down the line. In the process, the municipality had already agreed with him that it is partnering with him, and even written to third parties saying whatever he's saying it on behalf of the municipality. They had also agreed that he was going to conduct a feasibility study, which, according to my finding, he proceeded to conduct without really getting a clear go-ahead from the municipality. However, after conducting it, the municipality agreed to pay him, but later decided not to pay him because it was an unauthorized expenditure. So today, he hasn't been paid. The study was not really properly authorized. There was no real proper contract between the municipality and him, or rather a legally sound contract, which would be one entered in accordance with the law. So my finding basically is that the municipality did indeed renege on an agreement to participate in the fish farming project, and it also reneged on an agreement to fund 40% of the feasibility study. And I do blame the municipality for the mess, the paralysis in terms of fish farming. And as it is, no project has been implemented in terms of the IDP to deal with the poverty alleviation. And fish farming offered a possibility to do that. The complainant has argued that further that the municipality wronged him in that it said Jericho was not a possibility because there was a water contamination, but I'm not able to find in his favor in that regard. I have called upon the municipality to pay APC or Mr. Mdluli at least 100,000 rand as consolatory payment for the perilous journey it sent him through. The reason I've not been able to order that he be paid the millions that he's asked for is that there's no clear nexus between all of what he suffered and what the municipality did. He clearly did suffer. The question is, what portion of that suffering can be legitimately attributed to the Bujanala municipality? The Bujanala municipality was given a provisional notice in terms of Section 7.9 of the Public Protector Act, and I'm happy to say that it accepted the finding and accepted to pay the amount of no less than 100,000. It will now be a deal between him and them in terms of whether or not they could pay him more than that amount. The third report goes under the title A Matter of Interpretation. It communicates my findings and remedial action I'm taking in terms of Section 182(1)(c) of the Constitution, having concluded an investigation into complaints lodged by Ms. Slabbert and Mr. Dimbowski, a chairperson of the Justice Project South Africa. This was a complaint against the Johannesburg Metropolitan Police Department, which is JMPD. And the complaint was that the Johannesburg Metropolitan Police Department failed to comply with the provisions of its founding legislation in implementing in issuing infringement notices against road users in the Johannesburg area. They argued that those infringement notices were unlawful and unenforceable since they were not dispensed in accordance with Section 30 of the ARTO Act. My finding has been that the JMPD did violate the ARTO Act. However, the infringement has now been corrected. The infringement notices were incorrectly issued as they did not comply with the requirements of the Act. I have not requested any remedial action. As I've indicated, the JMPD considered it had made a mistake and has corrected the impropriety. That's basically the key finding around ARTO. I would like then to, in terms of the remedy, although there isn't any remedial action in terms of any refunds or something like that, the JMPD has been asked though to apologize to those who were adversely affected by the wrongful action that it took. I now go to the main report. The main report goes under the title Broken Promises. Broken Promises is my report as Public Protector issued in terms of Section 182(1)(b) of the Constitution of the Republic of South Africa and Section 8, subsection 1 of the Public Protector Act number 23 of 1994. The report relates to an investigation into alleged maladministration relating to the city of Joburg that allegedly failed to comply with its bylaws and the Constitution in connection with illegal occupation by COJ residents of 2 privately owned buildings. The alleged wrongful action by the city of Joburg involved failure to terminate services as advised by the complainants and unduly billing the complainants for such services. The city of Joburg also allegedly failed to reverse wrongful billing despite numerous undertakings to do so, and also allegedly failed to keep promises to help with the eviction process while encouraging the said illegal occupation. The illegal occupation of buildings or hijacking of buildings has become a major nightmare for investors seeking to earn their fortune through property or to use purchased properties for business purposes. While the phenomenon appears to be a national one, anecdotal evidence suggests it is particularly rife in the city of Joburg within the Gauteng province. The complainants, Mr. Tsepo Gaudi and his wife, Ms. Pindi Gaudi, are young business persons that jointly purchased two property-owning companies, Blancomet and Lujek, in Jeppestown in the city of Joburg. They intended to use the buildings for a shoe factory and other commercial purposes. During 2009, the complainants were requested the city of Joburg to execute electricity cut-offs in the buildings as they were occupied by illegal occupiers. The alleged illegal occupiers were mostly business persons who had been tenants of a business person whose bid to purchase the buildings had fallen through on account of non-payment before the buildings were sold to the complainant and his wife. The complainants allegedly approached the city of Joburg for assistance, and certain undertakings were made but never honored by the city of Joburg. At the core of the complaint is that the city of Joburg improperly undertook to help with evictions without a court order and later advised it couldn't after laying down various compliance requirements that the complainants complied with, losing time and money in the process. The city of Joburg allegedly failed to hold one of its councillors, Councillor Swanning, for encouraging the illegal occupation of buildings and interfering with eviction attempts in the said buildings. The city of Joburg allegedly wrongfully failed to terminate electricity and water services to the buildings despite being asked and undertaking to do so several times. The complainants also alleged that the city of Joburg wrongfully billed them for the illegal consumption of services, leading to a huge liability which undermined their attempts to sell the buildings. The city failed to honor promises to reverse the wrongful billing despite undertaking to do so several times, and generally failed to honor its bylaws regarding law enforcement on illegal consumption of municipal water and electricity, and for years failed to honor its constitutional responsibility to provide access to housing, including emergency housing, to its residents, leaving the complainants and their family to shoulder such responsibility. The background to the complaint as presented by Mr. and Mrs. Gaudi, with minimum disagreement from the City of Joburg officials, is the following. 2008, the Gaudis purchased two companies owning a building each in Jeppestown, with each occupied by a few tenants from a previous business person whose attempt to buy the buildings had fallen through. 2009, the City of Joburg is requested to cut off services, and this is not done. 2010, the complainants commence an eviction process with an attorney up to issuing eviction notices. 2010, the Premier's office is approached, which refers the complainants to a task team within the Department of Planning and Urban Management in the City of Joburg, which promises to conduct a raid provided the complainants give proof of having secured security services for the building to ensure there is no reoccupation, among other things. 2011, the complainants secure a private security company which deploys resources to the building, and then Mr. Khawudi provides proof of such to the PDUM of the City of Joburg. September 2011, the promised raid is conducted, but instead of the people being evicted, they're given notices, because just as they are going towards the building to conduct the raid, Councillor Zwane calls Mr. Khawudi and threatens him and tells him that the people can't be evicted. Incidentally, Mr. Khawudi says that this was shortly before the elections, and Mr. Councillor Zwane depended on that constituency for his elections, so that's something we haven't really investigated. September 2011, the mayor is approached about unkept promises, and Councillor Zwane's alleged criminal conduct. And October 2011, a meeting takes place at the COJ where discussions around the reversal of charges, disconnection of services, etc. are discussed. February 2011, the presidency has now been approached. It holds a meeting between the COJ and the Khawudis. Promises to reverse the charges are made again, and at this stage, the Khawudis no longer want the buildings and they offer it for sale to the City of Joburg. April 2011, none of the promises have been kept, and the protector is approached by the Khawudis. And December 2012, Public Protector is informed that services have now been cut and wrongful charges have been reversed. Turns out that hasn't happened. And actually, the services were only terminated at the beginning of last year. That's basically the background. Today, the Khawudis have lost everything, and their home is in the process of being sold in execution of a court order, while the two buildings remain unavailable for use due to the illegal occupation. An attempt from my office to get Legal Aid South Africa to help with the eviction process was aborted due to the complainant's inability to raise fees for the sheriff to self-process as required by law. Legal Aid South Africa also did not have the money for the sheriff, so that process could not move forward. The COJ has not denied that when the complainant started on this perilous journey with the city, they were young, fairly successful business persons who had been able to mobilize capital, who had been able to mobilize the capital outlay to pay for 2 multiple-story buildings for use as a shoe factory and other commercial purposes. It is undeniable that before purchasing the buildings, the Kawudis were successful business people who owned a multiple branch shoe business with shoes manufactured in Brazil. It is also undeniable that their business started falling apart when the two buildings, purchased at cash with a view to domesticating the shoemaking business and creating jobs in the process, could not be used for the purpose for which they were purchased. It has also not been denied that at the time of the complainants purchasing the buildings, there were already occupants, albeit quite few, who had been installed by a business person who was in the process of purchasing the buildings from the original owner but failed to secure funding. Thus means the risk of illegal occupation was not created by the city of Joburg. The COJ also did not have a duty to evict anyone, and in fact doing so without a court order would have been illegal and unconstitutional. If the COJ did not cause the illegal occupation, nor did it have a duty to evict the illegal occupants, what then was its wrong? On analysis of the complaint, the following issues were identified and investigated. A, did the COJ wrongfully fail to disconnect electricity and other services at the complainant's illegally occupied buildings in violation of its own municipal bylaws? And if so, does such conduct constitute maladministration? B, did the COJ improperly bill the complainant's companies for electricity and water services in respect of the complainant's illegally occupied properties? And if so, does this constitute maladministration? C, did the COJ promise the complainants and the presidency to disconnect municipal services and write off a debt for improperly rendered services relating to their property and later unduly failed to honor such promise? D, did the city of Joburg improperly encourage the illegal occupation of the complainant's buildings by failing to take action against Councillor Swane, who actively encouraged and admitted to encouraging illegal occupation of the complainant's buildings? E, did the COJ unduly fail to take resolute criminal action against illegal occupants in violation of its own bylaws? F, did the COJ improperly undertake to assist the complainants with an eviction process and in the process cause them to incur security costs for security meant to guard the buildings at the conclusion of an eviction process? G, did the COJ fail to discharge its responsibilities in terms of the right to property under Section 25, right to access to housing under Section 26, duty to ensure good administration under Section 195, and duty to give priority to constitutional obligations under Section 237 of the Constitution? H, did the complainants and their families suffer prejudice or injustice due to one or more acts of maladministration by the COJ? I, if the complainants and their family suffered prejudice or injustice, what would it take to place them as close as possible to where they would have been but for the COJ's maladministration? The investigation commenced with an attempt to mediate with a view to endeavoring to help the parties resolve the dispute by mutual agreement. When the mediation failed, a formal investigation conducted through meetings and interviews with the complainant and relevant officials of the department, as well as an inspection of all relevant documents and premises, and analysis and application of relevant laws, policies, and prescripts followed. The executive mayor The mayor was also engaged through face-to-face meetings and telephone conversations throughout the process. In this regard, I'm grateful for the mayor's compassionate response, including agreeing to have his officials negotiate with the financial institution to delay the eviction of the complainants from their home pending the finalization of the investigation. The COJ assisted in negotiating with the financial institution in putting an auction that was supposed to take place in abeyance. It is worth noting that the COJ has not denied many of the alleged acts of maladministration relating to failure to terminate services, wrongfully billing the complainants for illicit consumption of services, failure to timely reverse the wrongful billing, and many other improprieties. It is also worth noting that the COJ has not denied that no formal investigation or disciplinary process was instituted against Councillor Zwane for possible violation of the relevant code of conduct. On the issue of law enforcement, the COJ has considered that sport fines were only issued once against the illegal occupants and that no arrests have ever been made. In this regard, I understand that arrests have to be made by the police, but when the consumption of electricity illicitly is against the COJ, it is the COJ that has a duty to make sure that the police are aware of a crime being committed and action is taken to ensure there's no impunity. In other words, the illegal occupation of the complainants' buildings has principally taken place mostly with impunity insofar as law enforcement is concerned. The COJ has also not denied promising to raid and evict illegal occupants at the said buildings, but explained that it was an unlawful promise, as the law only allows court-authorized evictions, and that's true. However, it's worth noting that the COJ has to date not indicated its specific solution to the accommodation of the said illegal occupants as the bearer of responsibility for public housing in its jurisdiction, both on an emergency basis and in the long term, as stipulated by the courts in the Blue Moonlight Properties case and the Grootboom judgment, respectively. In the main report, though, I will indicate that the COJ denies that it has any responsibility to provide housing under Section 26 of the Constitution. It says that's the responsibility of provincial and national government. We disagree. We believe that this is a shared government responsibility. In any event, the key issue in regard to these occupied buildings is not the issue of permanent accommodation, it's the issue of alternative accommodation that these people could go to so that they can leave these buildings to Mr. Khawudi and his company. The key laws taken into account to help me determine if there had been maladministration by the COJ and prejudice or injustice suffered by the complainants were principally those imposing administrative standards that should have been upheld by the COJ and its officials when dealing with the complaint raised by the complainants regarding the illegal occupation of their buildings and the illegal consumption of electricity and water in their buildings. Having considered the evidence uncovered during the investigation against the relevant regulatory framework setting the standard the COJ should have complied with, I make the following findings. 1. Regarding whether the COJ wrongfully failed to disconnect electricity and other services at the complainant's illegally occupied buildings in violation of its own municipal bylaws, and if so, whether this conduct constitutes maladministration, I find that A. The COJ failed without good reason and over a long period of time to disconnect electricity services to the complainant's illegally occupied properties. This is contrary to the COJ's debt control policy and Section 95 of the Municipal Systems Act. The acts of the COJ constitute maladministration as envisaged in Section 6 of the Protector Act, and improper conduct is envisaged in Section 182 of the Constitution. Number 2, did the COJ improperly bill the complainant's companies for electricity and other services in respect of the complainant's illegally occupied properties, and if so, does this constitute maladministration? I find that the COJ did improperly bill the complainants for services it wrongfully supplied in violation of his and his predecessors' requests to terminate services. The city also contravened Section 95 of the Municipal Systems Act of 2000, read with the COJ's credit control and debt control and debt collection policy. B. The acts of the COJ constitute maladministration as envisaged in Section 6 of the Protector Act and 182 of the Constitution. 3. Did the COJ promise the complainants and the Presidency to connect municipal services and write-off debt for wrongfully rendered services at their properties and later improperly fail to honor such promise? I find that the allegation regarding making and unduly failing to keep a promise to disconnect electricity and water services to the illegal occupiers so as to discourage their occupancy and to reverse existing wrongful billing for such illegal consumption has been substantiated. B. The COJ failed to keep its promise not only to the complainants and the Presidency, but also to my office, not once, but several times. C. The acts of the COJ constitute maladministration as envisaged in Section 6 of the Protector Act and improper conduct as envisaged in Section 182 of the Constitution. 4. Did the COJ improperly encourage the illegal occupation of the complainant's buildings by failing to take action against its Councillor Zwane, who actively encouraged and admitted to encouraging illegal occupation of the complainant's buildings? I find that A. By its own admission, the COJ did not subject Councillor Zwane to a disciplinary process for possible violation of the Code of Conduct for councillors. B. By failing to take resolute action against Councillor Zwane, the COJ did encourage not only illegal occupation, but risk setting the scene for other councillors to do what he did, expecting impunity. C. By not taking action or instituting an investigation into the matter, the COJ contravened Section 2 and 6, subsection 1 of the Code of Conduct of Councillors as provided under Schedule 1 of the Municipal Systems Act of 2000. Furthermore, the COJ contravened Section 11A and D of the Code of Conduct of Councillors by interfering with the management and administration of the municipality without authority. The acts of the COJ constitute maladministration as envisaged in Section 6 of the Protector Act, and improper conduct as envisaged in Section 182 of the Constitution. 5. Did the COJ unduly fail to take resolute criminal action against illegal occupants of the complainant's buildings in violation of its own bylaws? I find that A. The COJ did indeed fail to enforce its own bylaws. The COJ failed to comply with Section 15 of the Greater Johannesburg Metropolitan Electricity Bylaws, which state that no other person other than an employee of the council authorized thereto shall, without written permission from the engineer, connect or reconnect or attempt to connect or reconnect any electrical installations to the service connection or the supply main. The acts of the COJ constitute maladministration as envisaged in Section 6 of the Protector Act and improper conduct as envisaged in Section 182 of the Constitution. 6. Did the COJ improperly undertake to assist the complainant with an eviction process and later fail to do so, thus causing the complainant to incur a security cost for security meant to guard the buildings at the conclusion of the eviction process? I find that the COJ undertook to do something unlawful by wrongly advising and undertaking to assist the complainants in the eviction of the unlawful occupiers without a court order. While it did not have the power or authority to do so, and accordingly could not legally deliver on its promise. B. The COJ failed to conduct a proper assessment of its powers and accordingly advised the complainants wrongly in violation of Section 195(1) of the Constitution and Batupili Principle 5. And because of the wrong advice, he lost time and money. In the report, I explained the requirement of Section 195(1), which require those in the public service to give members of the public accurate information on services they are entitled to. The acts of the COJ constitute maladministration as envisaged in Section 6 of the Protector Act and improper conduct as envisaged in Section 182 of the Constitution. 7. Did the COJ fail to discharge its responsibilities in terms of the right to property under Section 25, right to access to housing under Section 26, duty to ensure good administration under Section 195, and duty to give priority to constitutional obligations under Section 237 of the Constitution? I find that A. The COJ has known about the need for housing for the illegal occupants occupying the complainant's buildings for at least 6 years. In fact, we have found that it has known for exactly 12 years because the other person had warned them about that problem as well. But effectively, we are mentioning 6 years because that's the time Mr. Khawudi and his wife advised the city of Joburg about the need to disconnect services in those buildings and later asked the city to assist with the eviction process. By failure to comply with its housing responsibilities, the COJ has caused the complainants to shoulder its responsibilities and those of other responsible organs of state with regard to the right to access to housing under Section 26 of the Constitution, in violation of the complainant's right to enjoy his property under Section 25 of the Constitution. B. The COJ failed to discharge its constitutional responsibilities, particularly as outlined in the Blue Moonlight Properties case, and under Section 237 of the Constitution, requiring constitutional obligations to be given priority and performed with diligence. C. The COJ failed to honour promises made to the Public Protector arising from a meeting held on 23 September 2014, according to which the COJ would assess the complainant's buildings with a view to possibly acquiring them for temporary accommodation of COJ residents. D. The COJ's treatment of the complainants involving unmet promises and being misled further violates principles of good administration in Section 195 of the Constitution and the Batubili principles, particularly Principle 5, assuring the public that it will be given accurate information on public services they are eligible for. E. The acts of the COJ constitute maladministration as envisaged in Section 6 of the Public Protector Act and improper conduct as envisaged in Section 182 of the Constitution. Were the complainants and their family prejudiced or suffered injustice due to one or more of the city's acts of maladministration, I find that the complainants were severely prejudiced by the COJ's maladministration, and such prejudice was financial, emotional, and psychological. While providing free accommodation to residents whose responsibility to house is the government's, the complainants have neither been able to use their two buildings for commercial purposes they were procured for, or to sell them for a fair return. Had they not been misled and wrongfully billed, the complainants would have probably been able to timely evict the illegal occupants and or sell the buildings at reasonable value early in the process. One of the sales opportunities fell through recently because, among other things, the utility bill was still wrongly reflecting a huge amount as owed by the building to the COJ. The complainant's family and employees have also been prejudiced by the COJ's maladministration. The appropriate remedial action I am taking in pursuit of Section 182(1)(c) with a view to placing the complainants as close as possible to where they would have been had the improper conduct or maladministration not occurred is to call upon 1. The mayor of the COJ to do the following. A. Cause and agent evaluation of the complainant's buildings. Approach the council with a request to buy the buildings as redress for harm caused to the complainants by the COJ. B. Ensure that an internal investigation on the cause of the COJ's failure to provide Mr. Khawudi with service expected under Section 195 of the Constitution and Batubili principles is established. Ensure that an agent investigation is conducted in respect of all privately owned buildings that are illegally occupied. Ensure that the COJ complies with its responsibilities to provide emergency housing. D. Apologize to the complainant's family for the gross maladministration and consequent trauma. The chairperson of the Municipal Council to ensure that appropriate action is taken against Councillor Zwane in terms of the COJ's Code of Conduct for Councillors, and to report to the MEC for local government in the province on the matter. B. Assist the mayor with the above remedial action. I just want to indicate that the remedy we're giving to Mr. Khawudi is not a remedy available to everyone whose building is illegally occupied in the COJ. And that was one of the main concerns by the mayor. The only reason Mr. Khawudi is being assisted in the manner we are trying to assist him is because of the broken promises. It is not because the city failed to provide accommodation to those people only. That I just wanted that to be understood, because the city was worried about floodgates. Lastly, it was a year of great moments and a year of turbulence, and yet it has been a wonderful year. We've learned from it and hope all organs of state and role players have also learned and will grow from the experiences. As we move into 2015, let us commit ourselves to walk the talk better on good governance and to play our part in ensuring that the state becomes more accountable, operates with more integrity, and is more responsive to all. Happy holidays, and to those that celebrate Christmas, Merry Christmas. Thank you.
Thank you, Public Protector. We will now open the floor for questions, but before we do that, I just want to introduce my colleague sitting to the Public Protector's left, Advocate Madonsela, who is a senior investigator, good governance and integrity. He assisted the Public Protector with the R2 investigation. On that note, then I will open the floor for questions. Any takers? Recognize Mr. Masumbuka from the Times. I want us to take them in batches of 5 at a time. Are there any takers? Okay, in the absence of more questions, I will ask my colleague Jeffrey to assist with the roving mic so that Mr. Masumbuka can pose his question. Thank you.
Thank you so much, Super Masumbuka, for the Times newspaper. Just a bit of request for more information. Are you able to tell us, Advocate, how much did the complainants pay for the two companies that own the two buildings, and how much will they bill for the services consumed by the illegal companies?
Thank you, Mr. Masumbuka. Any more questions before I hand over to the Public Protector to respond? There doesn't seem to be any more questions. I'll give the Public Protector.
Thank you, Mr. Masumbuka, and thank you to everyone. I just want to also use this opportunity to thank all of the investigators that have assisted with the investigations. Advocate Masilela assisted with the R2 investigation. Advocate Johan Robenheimer was here earlier, assisted with the investigation on fish farming paralysis, and with the investigation into the city of Joburg on broken promises. I was assisted by Ms. Lisedi Sikele, Mr. Kekana, Debucho Kekana, and Mr. Risenga Maruma, and I thank all of them for their assistance. Mr. Masumbuka, I don't recall on top of my head how much did the buildings cost. However, they were purchased quite a while ago. They were purchased around 2008. Yeah, between 2008 and 9. They cost a couple of thousands then, and the value right now, I think, is about 1 million. I would say the best person to answer the questions is Mr. Tsepo Kawudi, who would be willing to speak to you about it. The billing on the building was a couple of thousands. Initially, after the intervention of the presidency, the bill was reduced a bit, but it wasn't totally written off. And after our intervention, eventually the bill was reduced, but it was over 1 million. The bill for the two buildings was over a million, I think a couple of millions as well. I will apologize for the fact that I can't remember the specifics, which brings me to how we're going to deal with this thing in the future. What we've been doing up until now is to release a lot of reports together. We will only now be releasing systemic investigations, and the other smaller reports we will be sending press releases on them and promoting them through the radio, so that on these briefings we can, like our colleagues in other countries, just focus on one report at a time.
Any more questions from the floor? There doesn't seem to be any questions from the floor. In the absence of such questions, then I will be forced to adjourn the press conference. Thank you. Unless PP, you have got closing remarks you want to make before we close.
Just to say thank you to the media and to the people of South Africa for their support and for the scrutiny. I was being sincere when I was saying that my team has benefited from both the positive and the negative feedback, and we're very excited about the strategic conversation we've been having in the last couple of days on some of the things that we plan to do differently next day. And we wouldn't have thought through those things had we not been pushed out of our comfort zone. Thank you.
Thank you very much for coming, ladies and gentlemen.